People being kept in prison, in custody, waiting for a trial years and years is just quite contrary to justice. Parliament has the ultimate authority to set aside a court's decision, but as far as I'm concerned, that requires that there's a good reason for doing it. It really is a very satisfying thing if you feel you've chosen people that do well. And I don't want to claim too much, but on the whole, I think my choices have turned out to be pretty good.
This is The Judges, Power, Politics and the People, hosted by the University of Law. This week, I'm speaking with Lord Mackay of Clashfern. James Mackay is best known as having been Lord Chancellor for 10 years, from 1987 to 97, in the governments of both Margaret Thatcher and John Major. An outsider to the English legal profession, he brought in some of its most far-reaching reforms, ending the bar's monopoly of advocacy in the higher courts and the solicitors' monopoly of conveyancing. He also made some of the most influential judicial appointments of the last 50 years, including that of Lord Bingham of Cornhill as Lord Chief Justice. James Mackay has had a distinguished career as an advocate, judge and politician. He quickly rose through the ranks in the Scottish legal profession, becoming Lord Advocate, its most senior law officer, before being appointed Lord Chancellor. Until his retirement last year, he was an active member of the House of Lords. I began by asking Lord Mackay how he started in the law.
I started off as a mathematician, and I managed to do that up to the tripos in Cambridge and got parts 2 and 3. And then I had already done the national service, so-called, as a lecturer in St Andrews University on mathematics. And I just wondered then whether this was a life for me for the rest of my life. And I rather thought not. So I was in court one day and just listening in Edinburgh, and I thought this maybe do for me.
You'd just gone in because you were interested
yes,
to see
interested, just to see what it was like.
Yes.
I had been, when we were at school, we had been taken there, but I hadn't been there after it. And I thought to myself, that was quite interesting. I'm quite interested in that. But in order to go into the university court for the LLB, I had to have Latin. And I had no Latin at school at all. So I had to get round to getting a Latin qualification in time for admission in September.
So you had to learn Latin from scratch?
From scratch, and very quickly. And of course, I managed to get it and get in. And so I started the course, and it was a 3-year course altogether.
This was to qualify?
As an advocate. And I became an advocate in 1955, and I got on reasonably quickly.
Just before we move to your career, you mentioned your school taking you to the courts. What school was it that you went to?
Heriot.
And was it an ordinary state school?
George Heriot was the treasurer of King James VI when he came to London. And he did pretty well in London, and he managed to have quite a large amount of money. And he set this up as a school in Scotland in 1628, I think it was.
Was it a fee-paying school?
No, well, it was a fee-paying school, but I didn't have to pay fees except for the first year. And there wasn't it wasn't like a private school in the kind of area that you know in this part of the world.
You went on a scholarship?
Yeah, I got a scholarship after the second year, and I had that all the time. And also they gave me a scholarship to go to the university.
Because otherwise, you came from quite a humble background, didn't you? Tell me what your parents did. My
father had been on the railway, but he had suffered from tuberculosis, and he had to give it up, and he retired quite early. And my mother was a widow of earlier days, and they had got married, and I was the only child that they had, and it was quite an interesting, rather special type of life. But anyway, that's how.
And difficult, would you say, financially difficult?
Well, it needed, they needed to be careful. They weren't very open with money.
No.
They had to be careful.
But no connections with the law?
None whatsoever. My father was if he had dealings with solicitors, he was very respectful to them. And when I changed from mathematics to the law, he thought I'd done quite a good thing, because he couldn't understand what the mathematics was about and what I was trying to do. Whereas once I became a lawyer, he knew more about it.
That's good. So you went off and you did your 3-year training to become a lawyer, and you became an advocate, and you built up a specialist practice, as you say. Now, at some point, you decided to go into the government, didn't you? Well,
I was asked, and I had become the Dean of the Faculty of Advocates, which is the leading position in the Faculty of Advocates in Scotland, which was, of course, the equivalent, much smaller, of the bar in England and Wales. And so we called ourselves advocates rather than barristers. And I found myself doing quite a lot of work in the House of Lords in that. And then when Mrs. Thatcher was elected as the Prime Minister, she phoned me up on the Monday after she had been appointed as the Prime Minister to ask me if I would become the Lord Advocate of Scotland.
How did she know you?
Well, that's a mystery that I don't quite know. It was Nicholas Fairbairn was there, and he was the senior member of the bar that was a Conservative. But I think she was anxious that her Lord Advocate would not be Nicholas Fairbairn, and he became the Solicitor General under me. Anyhow, in due course, I became the Lord Advocate. Now, the point about that is that it enlarged my legal practice very much, because as Lord Advocate, I was made a member of the House of Lords, and the Attorney General was the gentleman who ruled these matters in England and Wales. And he nominated me to defend the England and Wales government in 2 major cases in the Lords, and we won both of these.
So you got a high profile suddenly from getting this appointment.
Yes, that's right, quite a high profile, and I did a lot of work in the Lords helping different departments who were doing fairly important changes in the law, and I did quite a lot of that. So although it was, in a sense, a government position, the main consequences of it for me were very much more experience of the law, and I did quite important legislation as well at that early stage.
Yes, and could I just ask, presumably Margaret Thatcher knew that you were a Conservative by inclination, or was that nothing to do with it?
Well, I think she would know that, I think. I mean, I wasn't a politician in any sense of the word at all. Indeed, I believed that as a senior member of the bar, you had a duty to be pretty independent.
Absolutely. And when you came on, in fact, and we'll get to this, when you came on to be Lord Chancellor, you were actually, I wouldn't say, you were quite a radical, put it like that.
Yes. I wasn't devoted to any particular line like people that had been together in Cambridge and so on. I had to come with my own ideas.
Yes, you were something of an outsider. So when you were you were Lord Advocate, how long did you do that for?
5 years.
Yes.
And then I became a judge of the Court of Session and the High Court of Judiciary in Scotland. And then I was appointed to be a member of the House of Lords, the Lord of Appeal in Ordinary. And it's from that I was appointed as Lord Chancellor in 1987.
So how long did you sit in the House of Lords as a judge, as an appellate?
About 2 years.
About 2 years. And how did you find that? Was that quite different from anything you'd done before?
Yes, it was different. And at first I was the junior, and the rule was that at the end of a hearing, they asked the junior to say what he thought was the right answer. And I was fortunate in that the first term after I became a member, 3 new judges were appointed, Ackner and 2 others, and they were all therefore junior to me, and the 3 of them were vulnerable to being asked. And
so you didn't have to get lumbered with that question anymore after
that's
that.
Right, exactly.
That's quite a thing, isn't it? You had to, before you'd heard the benefit of anybody else, you had to say what you thought.
That's right, that's right.
Were you aware in that position as a law lord, were you aware of the power that that court had and in creating law? Or?
Yes, I was. And I was very interested in it too. I had appeared quite a lot on the Lords. I had some experience of taking appeals from Scotland to the Lords, and also English cases in the Lords I was asked to do quite a bit of for reasons which, just because they wanted me to do them.
Had you when you first entered the bar in Scotland, had you any ambitions to go onto the bench?
No, I had the ambition to do my best to have a good practice, and I certainly I got
and you did that?
A good practice.
So it was quite a decision to make to then go onto the bench?
Yes, well, that was at the end of my time as Lord Advocate. I thought it was right then that you give up and become a judge. That was the normal thing to do, so I did that and became a judge of the Court of Session, but that only lasted a year or so because I was appointed to the House of Lords.
Yes, and tell me first of all, before we go on to your appointment again as Lord Chancellor, what can you pick out a 1 or 2 rulings of which you were particularly proud?
Well, I was really pretty keen. I was the Revenue Junior when I was an advocate, and so I was fairly familiar with revenue law, and I did quite a few cases in that connection, and they were quite important cases of that sort. That's the main area in which I did cases at that time, but I was quite fortunate in other respects too, that I got cases which were requiring interpretation of wills and that sort of thing.
And is there any one that sticks in your mind as being very difficult for you to decide, that you agonised over?
No, I just, if I was asked to do it, I did it and I did my best. There were quite a few of that sort of victories which just happened to be.
You were then appointed by, as you say, Margaret Thatcher to be Lord Chancellor. How did it happen? Did you actually speak to her?
Well, she spoke to me.
Right, she phoned you up, did she? Or did she ask you to come and see her?
I got a message from the Leader of the House that afternoon. I had gone down after the session as a judge, as a Lord of Appeal, to listen to the argument in connection with a particular piece of legislation. And I was sitting there and suddenly a message came along from the leader to say that I was wanted to speak to the Prime Minister. So I went along at the time appointed, and I had no idea what it would be about, none whatsoever. And I came into her office and she said, "Please sit down." And then she said, Lord
Havers.
Yes, he had retired because of ill health, she said to me. And she said, "We would like you to be the Lord Chancellor."
What did you think?
Well, I said to her, it's a very big honour. And I said, "You know as well as I do that any appointment of that kind affects your family. And therefore I would like to ask my wife before I give a final decision." She said, "There's the telephone."
Oh, she wanted you to ring your wife there and then?
Yeah, she wanted me to speak to her at once. Well, I tried to phone, but she was out.
Yes.
Well, she said, "Let me know at once whenever she comes in."
Yes.
So, needless to say, I was phoning away, and she came in eventually. And
I think your wife was out shopping, was she? Or
yes,
like
she was shopping, and in a way that happened to be quite important. But Anyway, she said, you know, you can't turn that down. So
well, that was good. So she said, encouraged you to go for it.
And, you know, Mrs. Thatcher wanted to put the appointment out that evening because she wanted it to come out immediately after the resignation. So it came out at 7 o'clock that evening. And the officer of the Inner Temple phoned me up in the evening after that to say that they had a difficulty because they had arranged a dinner for the Lord Chancellor and his wife for Wednesday. So I said to him, well, you can just ask Lord Havers what he wants, but I would think it'd be perfectly all right to go ahead with the dinner. So when he phoned up Lord Havers said, certainly, we'll do that. So the dinner
went ahead
on the Wednesday.
And of course it was all printed out, Lord Chancellor.
Yes, not the name.
No, that was
Just
fortunate.
Dinner in honour of the Lord Chancellor. And he spoke first, needless to say, and he was very kind to me. And he indicated that he felt he couldn't really cover the things, the sort of jobs that were involved. His health had been not great for some time.
So he spoke and he gave you a generous introduction.
Yeah, that's right.
That was very nice.
Very nice. And it's interesting that what Bet had been out shopping for was the dress she wore that evening.
Well, that was very timely. When Margaret Thatcher appointed you, did you discuss at that point or soon after that she wanted various reforms of the legal profession?
No. She left that entirely to me.
So when you did, of course, implement some very far-ranging and quite wide reforms.
Yeah, well, the bar and the solicitors, the Law Society, had been at loggerheads about the rights of audience in the superior courts for some time. And they eventually decided to have a committee set up to assess this. And they set up a committee with 10 solicitors, 10 barristers, and 10 independents, and with an independent lady as the chair. And
Lady Marr, wasn't it?
Lady Marr, that's right. She was completely independent.
Well, they couldn't reach a conclusion, really, could they?
Well,
they were deadlocked.
Eventually, I mean, when I was appointed, the people had been looking at this. People other than those that I knew had been looking at it, and I was asked to write a paper for the government committee that was concerned with these matters about what I would think. And my view simply was that if you know what you're doing, you should be allowed to do it.
So in other words, you were proposing getting rid of the bar's then monopoly of the higher courts.
That's right. But I said it's being subject to a committee, and we shouldn't do anything until the agreement comes out. And in due course, the committee did come out, and there were 10 solicitors for getting the rights of audience to solicitors. There were 10 barristers who were against that, and the 10 neutrals were in favour of the solicitors. So it wasn't much of an agreement, if you like.
No.
So in that case, I decided with the committee that we should proceed. And what I wanted to do was to give rights of audience to solicitors so long as they were qualified to appear in the superior courts. Not to everybody, not at all, but to those who were qualified as a result of proper training to appear in the Supreme Court and the higher courts. And that's what I came forward with.
Yes, and that led to the Green Papers, and
yes.
quite a hullabaloo about it, wasn't there, with fierce opposition from the bar and the judiciary, it has to be said.
Well, some of the judiciary anyway. I wouldn't wish to make it too broad. There was qualification in the judiciary as to whether I was right. Anyway, it was quite a hullabaloo, and the bar were very, very strong on the point. And they raised a fund for dealing with this.
Fighting fund to oppose, these proposals.
I think it was about $1 million. Anyway.
Well, you became, I mean, my recollection of it is that you became quite a target of vitriol and abuse.
Yes.
And you were quite often shunned at dinners and things like that. People would turn their back when you were at drinks receptions and so on. Were you aware of how did you feel about the level of hostility?
Well, I felt it was rather sad. But I mean, I didn't feel that they ever produced a reason which was a good reason. If they had done, I would have considered it very carefully, but I didn't know any reason at all that they were opposed to what I was suggesting. And of course, you may remember that there was an organised debate in the theatre on the other side of the river.
Yes, the Times organised that.
That's right, and and we had the great questioner behind me. They sat me in a chair rather like this in the front of the gallery, and he was up behind. And one of his early questions was about the green paper. And he said, did the Attorney General, he's a member of the government, did he approve the green paper? I said, he is a member of the government, and this green paper is put out on behalf of the government.
So in other words, he was signed up to it. It was collective cabinet responsibility.
Yeah.
Everyone had endorsed it.
Anyway, that was my
That was your answer. It must have been a very difficult time for you, wasn't it?
Yes, in a way, but I mean, I felt strongly that what I said was right. And if they didn't care for it, that was a pity, but they hadn't produced any reason that I could understand which would knock me out.
No. And of course, one of the things they would say at that time was that you were an outsider. You were an outsider to the English legal profession. Did you feel very much an outsider at this time?
No, I had done a good number of English cases of different kinds in my time as Lord Advocate. And, I felt reasonably acceptable to the bar in that sense. I had cases in the highest court in the land in these days. I didn't feel too much.
You didn't feel out on a limb?
No.
When you had all these difficulties as Lord Chancellor and your battles with the bar and some of the judges, you're a man of, as is well known, of faith, and that's how important is your faith to you in your life, and how important was it at such times?
Well, I thoroughly believe that you shouldn't answer back, and I was keen to not do that. And I hope, if you look through what I said in answer to people that were speaking, I hope that it turns out that I didn't answer back.
Do you mean if they insulted you or said something?
That's right, nasty.
Yes, then you just took it.
I just took it.
And was that because of your belief that you should turn the other cheek?
Yes, and I honestly believe that it's much the best. I mean, there's no point in getting worked up about what people say about you.
Your faith has guided you in your decisions.
I hope so, and I certainly would like to believe that.
You were obviously known for your faith when you were in your job.
I hope so.
And there was, I think you... you were approached
I don't
by somebody...
any suggestion that I was perfect or that I did everything right and all that. I mean, I'm very conscious of the fact that I was not at all perfect. I was needing help continually. But on the other hand, I believe I got some help. As I said, I think at the very end of my speech, in the final speech, I believe that I got answers sometimes from what we pray for every day in Parliament.
And indeed, when you were abroad once in Israel, somebody approached you. Can you tell me about that?
Yes, well, we were, Ben and I were in Nazareth and looking around, and suddenly a lady came to speak to us, and she said, "Are you the Lord Chancellor?" And I said, "Yes." Well, she said, "I've got a group of people, mothers from Dublin, who are very anxious to see the end of these troubles. And would you be kind enough to pray with them for it?" So I said, "Certainly." And they all came, quite a big group came over, and we prayed together. And I do believe that since then, that prayer has been, to a certain extent anyway, answered.
It would be fair to say, would it, that the reforms which went through, and really now people don't think about them, but they were your idea rather than Margaret Thatcher's?
Well, Margaret Thatcher never explained any such idea to me. Mine was in the paper I was asked to produce, and it was just common sense so far as I was concerned.
The opponents predicted it would mean the end of the bar as we know it, but that, of course, hasn't happened.
Not at all, not at all. There's one gentleman said to me, "Well," they said, "you know, if this goes ahead, the bar will disappear on the van." Well, I said, if it does, it's a pretty good place to disappear. You know, but I had every confidence it wouldn't happen.
In fact, it's gone on from strength to strength, hasn't it?
Yes, it has.
And we now don't have monopolies. The solicitors don't have their monopoly of conveyancing. The bar doesn't have its monopoly of the higher rights of advocacy.
And the people that took that up were generally people that had specialist knowledge of a particular area of the law, like sound or,
Yes.
that kind of thing.
Yes. So if that was one of your legacies at that time, and quite a turbulent time, another one I think would have been judicial appointments, because you made some very key appointments.
Yes, I did.
Can you tell me a little bit about that and how you chose individuals to be, for example, Lord Chief Justice?
I made it my business to try to get to know everybody who was reasonably eligible to be promoted. And I listened to people, and I saw a lot of them at the different functions. I tried to attend these for that purpose. And I was very keen that there would be people who were qualified to be good judges, whatever their particular history was. And occasionally there was somebody with a rather peculiar, maybe political history. But I didn't think that mattered if I believed that they had the necessary competence to be a good judge. And as far as I remember, I think most of these people I appointed, or nominated for appointment, I should say probably, were good results. And one of the things I feel a degree of satisfaction with is as I look back over the people that I appointed.
Tell me the one or two of whom you're particularly proud.
Well, I don't like to single anybody out, because there are quite a few, and some of them were people with, political history that some of the newspapers felt was disqualification for.
Are we talking about here Stephen Sedley, for example?
Well, you have chosen one.
So he obviously had a background of being a member of the Communist Party, didn't he?
Or something like that.
Something like that. And you appointed him to the High Court bench.
Yeah.
Which showed that you were quite, as you said, that you took people from across the political spectrum, or irrespective of their background. So
long as I believed that they had the competence to be a good judge.
Yes.
And that's an example, if you like, of somebody who turned out to be extremely good as a Court of Appeal judge.
And name me one or two other key appointments that you made. Was Harry Wolff was one, was it?
Yes.
As Master of the Rolls?
Yes.
And Tom Bingham.
Yes, well, that was, I really, I believed very deeply that the Lord Chief Justice should be the leading judge in England and Wales. And I didn't feel that he should be just a criminal lawyer. And therefore I believed that Tom Bingham was really the most qualified. And I stuck to that, and the Prime Minister supported my point of view.
It was at the time slightly controversial because of that fact. That he didn't have a criminal background particularly, did he?
No, but he had the knowledge of the law, which was sufficient for the purpose of being the Lord Chief Justice.
And of course, people now praise him as one of the most significant and best appointments that have been made in the last few decades. Yes, well,
I thoroughly believe that.
Well, do you think that we can still get, of course, we haven't got this kind of system of appointment now. It all goes to a Judicial Appointments Commission. Do you think that's a good thing? And do we still get that level of standard of appointment?
Well, I found it a good level for me because it gave me the chance to really think through whom I was appointing and did my best to choose people who I believed were likely to do well. And I was asked some time ago, a good while ago now, to give a lecture about choice and how people were chosen. And I said, as part of that, I think it was the Birmingham University, if I remember rightly, I said as part of that it really is a very satisfying thing if you feel you've chosen people that do well. And I on the whole, I mean, I don't want to claim too much, but on the whole, I think my choices have turned out to be pretty good.
Yes, well, of course, you made those appointments, and that is not the way it's done now. We have a Judicial Appointments Commission, one of the reforms under Tony Blair, along with the setting up of the Supreme Court and the abolition of the Lord Chancellor in the way that it was when you held office. Can I ask you, first of all, about the judicial appointments? Do you think the present system works as well?
Well, I was very happy with the results of the system that worked when I was responsible. And I think it was important that a person, somebody is responsible, that you can say it was his decision. It was his decision or her decision. And I think that's quite important myself. But of course, if you appoint if a commission decides, you know, who did it, who was responsible.
There isn't the same accountability, is what you're saying.
That's right, not the same. And it's not the same choice, as it were. I mean, I'm very conscious, for example, of the business with Lord Bingham. I can't think that a committee would have had the same scope.
They wouldn't have been as bold.
No, I don't think so. I may be wrong.
They probably wouldn't think outside the box to the same extent.
That's right. And I was, well, just the way I thought to do it. And of course, I knew how good he was. I knew how good he was, and I knew the others that have been in place. And I did my best to choose the right people. And on the whole, I have no regrets about anybody that I did choose.
Was there any particular aspect? Did you have any errant judges that you had to deal with? There was trouble with judges speaking out in the media, I think, a little bit, wasn't there?
A little bit, but I believed that it was right to allow the judges to speak with some suggestion about how much care they should take, that being a matter for them. If they're High Court judges, if they're fit to be High Court judges, they should be fit to know what they can properly say.
You changed the rules, didn't you?
Yes.
And relaxed them.
Yes, that's right.
So it was down to individuals' discretion.
Yes. I thought this business of requiring the Lord Chancellor's permission was quite wrong. I really did. And, You know, I remember indicating that before ever I was thinking of being the Lord Chancellor.
As Lord Chancellor then, you had a very different role from the Lord Chancellor now.
Oh.
And you were head of the judiciary, you were their voice in cabinet. That isn't the same now.
No.
They're independent as a group, and the Lord Chief Justice has to fulfil that function. What's your view of the present arrangements, and now that we don't have a Lord Chancellor responsible for the judiciary in cabinet?
I really think the judiciary is an important part of our constitution. There's the executive, there's the legislative, and the judicial. And I think there's a question as to what representation the judicial has now in the arrangements for the government of the country as a whole.
Do you think they're in a weaker position because they don't have a person such as yourself speaking up for them in cabinet?
Well, I think that may be a problem. That may be, I mean, it depends who it is. You know, we've seen a few over the years since I came out of it. But it depends who's there.
Well, it does. I mean, that's the other thing. You held the job for quite a while.
10 years.
10 years.
Almost.
Now, we've had Lord Chancellors in position for a matter of months.
And
we've had a rapid turnover.
Yes, I must say, the Lord Chancellor's aspect is one thing, but I do think that it's very risky to change the minister very quickly, because getting to have a real grasp of what's going on in a ministry is quite a formidable task.
Because you had great respect in cabinet. Did you have any battles in persuading your colleagues for any of the things you wanted to do, or for standing up for the judges in the way that you had to do and doesn't happen now?
No, I didn't have anything difficulty about that at all. I don't recollect much in the way of disagreement with my colleagues.
Because you were quite senior. In fact, it fell to you, didn't it, to pay tribute to Margaret Thatcher?
It did.
On the day
end.
she... Tell me about that occasion.
Well, by the time, when I went into cabinet first, I was, I think, number 5 or something. But by the time she retired, I was number 2. So it fell to me to speak on behalf of the cabinet to her that day. And I did that with the help of Lord Butler, and a speech that intended to embrace the respect of the cabinet to her. And then she was going to speak, and she began to be...
Tearful.
Yes, a bit. So one of my colleagues said, "The Lord Chancellor will read it for you, Prime Minister." I said, "The Lord Chancellor will not read it. The Prime Minister will read it for herself." And immediately she got strong
And she was then able to do it.
Yeah, she did it.
Because you knew she would want that to be the case.
Yes, I knew very well that once she was faced with it in the way that I did, she would do it.
How did you get on with her generally?
Oh, I got on very well with her, very well. I mean, I never had any sort of dispute with her or anything. She supported me in all sorts of ways where I, didn't require any particular help. And actually, one of the things I should perhaps mention is that one of the reforms I wanted was in Scotland. And of course, Fairbairn and Company had decided that they were not having that. And there was not much I could do about that because there wasn't the same availability of strength. And I said to her, I was vexed that I did. "Oh," she said, "politics is the art of the possible." She said, "Don't worry about that at all."
She was comforting that you couldn't get it through in Scotland
That's
in
right.
the same way as you had with these similar reforms to the ones in England.
Yes, and actually in the end it's happened. I mean, the idea of having solicitor advocates is quite common in Scotland now.
Yes.
Not too many, but I mean there are some.
But they were resistant and you didn't manage to bring it about there.
No, then,
At
but
that
it
time.
came.
At that time, yes.
And,
but she was philosophical about it.
Yeah, absolutely. I felt, am I letting her down? But no, not at all.
Any other difficult issues you had to take to her or discuss with her?
Before I became Lord Chancellor, there were some quite difficult issues on the law in relation to the European Union. And I mean, I honestly think that work that she did then in getting a reduction in the amount that...
Oh, the rebate,
yes.
Was it? Yeah. Oh, no, it was the amount we had to pay, wasn't it?
Yes, and that was... she got that, although all the people she was discussing it with had the opposite point of view. Yet she got it.
She got it. What was your view about it?
Well, I just thought it was very admirable that she could do that. And she was very keen not to breach the law in relation to European Union.
So she was quite law-abiding?
Yes, she was very law-abiding. On the other hand, she was very good at using the law-abiding to go do what she wanted.
Yes, well, I'd like to come back to the attitude to the law of some of our recent office holders, but just before I leave your job as Lord Chancellor, do you think, though, the present arrangements give the judiciary a strong enough voice at the cabinet table, to put it like that? It was very different in your day, and you were there to defend them and speak up for them, but it's not like that now.
No, and it's quite difficult to know. I mean, I have a lot of respect for the present Lord Chancellor, but I mean, he only has the arrangement that he inherited.
This is Alex Chalk.
Yes, and he has. I mean, I don't remember having to deal with somebody who'd run out of prison. I mean, the Lord Chancellor to be deciding that sort of question.
Yes, because the prisons weren't part of your responsibility.
Not at all. And my word, I mean, it's not a very suitable arrangement to my mind. I mean, he's got the prisons, and a huge responsibility these are.
Well, that people say that draws his attention from the courts and legal aid and judges.
Yes, and the time for getting things done.
So do you think, I mean, if you were to revisit the arrangements we have now, some people favour having a Lord Chancellor with similar responsibilities as to those you had?
I think the difficulty, and I've spoken with some of my successors, not all, about this, is that once the Lord Chief Justice becomes the head of the judiciary in England and Wales, it's quite difficult to remove it from him.
Difficult to turn back the clock.
Yes, it is. It is. I mean, that's a reality to my mind. On the other hand, I think there's quite a lot to be said for the fact that the amount of sort of work, I've heard the Lord Chief Justice talking about the number of statutory responsibilities that he has. Well, you've got a lot of work to do as a judge, and all these intimate statutory responsibilities are quite something. And I think somehow there's something to be said for a political office, a ministerial office, dealing with that kind of thing. But, that's just part of what's happened.
You said that Margaret Thatcher was very law-abiding. We've had some ministers who've been, and prime ministers, who've been accused of having less of a regard for the rule of law and almost a flagrant disregard of it in some cases. Law officers as well, for that matter. Does it worry you the way that in recent years there's been a different attitude amongst our politicians? Well,
I think it's important. I would rather put it this way. I think it's important that we understand the effect of keeping to the rule of law in our country. I think it's a very important thing to do, and the more it's done, the better I feel with it.
Were you happy with Boris Johnson's approach?
Well, I mean, we've heard what the committee said now, and it's not for me to judge. I haven't been set up as a judge to judge Boris Johnson, but on the other hand, others have done it. Others have done the judgment. The whole attitude is rather different from what I thought.
How damaging is that then to the to the within government, that we don't have that respect for the rule of law, if that's what you're saying?
Yeah, well, I think it's very important to have it. That's my view. Very important to have it. And I don't want to start making decisions about people that are there when I haven't got that to do. But I do think that it's clear that the rule of law is an important part of our constitutional arrangements, and that it's right that we should keep it very much, so that we understand what the rule of law is. And that includes international law, of course.
And by that, I mean, you wouldn't expect us to go tearing up the European Convention on Human Rights or anything of that nature.
There are problems that some judges have raised in connection with the human rights arrangements, because now the judges in Strasbourg tend to feel that they have an authority to make rules which are not apparent from the treaty, and that has its own questions in it.
Do you think they've overreached themselves in recent years?
Well, some people think so. I haven't really had the responsibility to decide any of these questions, but quite a lot of people think that they have.
Do you have a view about whether we should remain a signatory to the European Convention?
Well, I certainly think that we should remain a signatory to the European Convention, because I think it's part of what holds Europe together from the point of view of law.
And the government, obviously, we've had this ruling against the plans to send asylum seekers to Rwanda, and the government has said they want to look at the legal framework and draw up a treaty which they think will meet the objections that have been raised and the Supreme Court have expressed concern about. Does that put the government in a difficult position? I mean, what's your attitude to that?
Well, I think it's quite a difficult question that they have, but if they can find a way of solving all these problems, well, it's pretty good that they can do that, but it's a difficult question.
It's a difficult question, and it puts the government in some ways a bit at loggerheads with the courts, doesn't it?
Well, I think that what the courts decide is something that the government should be able to deal with, and that may affect what they can do. But I don't myself think that it's right for us to have a country in which the government, the courts decide finally a case, and that is not something which the government has to deal with. I mean, the Prime Minister yesterday seems to be indicating that he believes he can deal with that. Well, if you can, that's very good.
Do you mean the courts should not have the final say on a matter? It should be for Parliament.
No, the courts have the final say on a matter for the courts. But of course, Parliament can legislate in a way that's contrary to what the courts have done, and they've done that on more than one occasion in the past.
Yes.
But it doesn't mean that if you've got a problem of that sort, it's quite difficult to... I mean, I think that the courts really have the power to decide, and of course Parliament has power to legislate, to change. I mean, there have been decisions over the years where Parliament has changed a decision of the court, and that's possible.
And that's as it should be.
That's the way it should be. If you're really setting aside something that the judges have done, that's not the same thing as implementing what they've done and trying to solve the matter in a way that conforms with the decision that they've taken about what's required. I mean, the Parliament has the ultimate authority to set aside a court's decision, but as far as I'm concerned, that requires that there's a good reason for doing it.
Do you think people understand the role of the courts? I mean, we've had these awful attacks on the judges with the ruling that led to the headlines, "Enemies of the People," when they ruled that the government couldn't trigger Brexit without the decision going before Parliament.
Yeah, well, I think that was
What did you think about that?
Didn't think it was right to say the judges were enemies of the people. I mean, that struck me as, well, I think I said that in Parliament. I didn't go on to say who was responsible for allowing that to happen, but I did say I think that it wasn't right for us to have a situation in which we set the judges against the people, because the judges are there to do their job, which is to set us to indicate what the law requires in a particular case.
Inevitably, with these political decisions, though, people are going to think there's a politics behind the judge's ruling, won't they? I mean, is that your experience, that judges come from a political angle?
I don't think it's right to. I mean, obviously, the way you're developed has an effect, and when you're chosen as a judge, I think it's quite important to realise that. But it's a different thing altogether to try to set aside a judgment as if the judges were politicians. They're not politicians. They're people deciding what the law is as a matter of law.
Do you think they leave their politics at the door of the court?
Well,
and can they?
I think that's quite a difficult question. But I think that it's a question of their honest judgment about what the law as it is at the present time when they're deciding it requires. It doesn't, of course, rule out the possibility that Parliament may have a jurisdiction to change that.
So looking at the way that the reforms over the years and the way the balance of power has maybe changed or not between the judiciary, the executive and Parliament, how do you see it at the moment? Is the balance about right? Is one of those three arms weakened? Would you say the judges have their fair crack of the whip, or how do you see it?
Well, I think the judges have rights which are perfectly good. What's important is that when they exercise these rights, it's recognised as that. And I mean, the thing about the enemies of the people was a ridiculous situation in the judgment of what the judges had decided.
Mm. Judges have, in a sense, become, in one way, more powerful because they've had to stand up to a perhaps a more expansive executive, do you think?
Well, that may be. I mean, the way the executive operates is quite an important aspect of the constitutional conduct of the government at the time.
Yes. Well, so looking at it all now, what do you think the biggest challenges are for the judiciary and for this delicate balance between the three limbs of the Constitution?
Well, I think it's very difficult to say what exactly should happen, but I do believe that it's quite important that the judges have somebody who is responsible to speak up for them if they're troubled, such as the case about the people. I mean, that was a ridiculous claim, and I think that the responsibility of the politicians who have responsibilities in these areas was not very quickly put into action.
No, well, in fact, it was at that time it fell to Liz Truss, didn't it? She was Lord Chancellor then. She didn't speak out very quickly, and consequently she was moved from that office not long after.
Well, that's what looks as though it happened.
But and the challenges for the future to keep that respect and to keep that understanding of what the judges do and what the ministers do and the rule of law, how can that be done?
Well, it's difficult, but I think it's important that the arrangements are such as to keep that in view. And I mean, the people, the advisor, the law officers have a responsibility in that area.
Do we have good arrangements now, or do you worry about the balance of power?
Well, I'm a bit anxious from time to time. I just hope that it'll be solved properly. But it's not easy. I mean, the questions now about the boats and so on are very tricky.
You had quite an influence in your time at the Lords. I mean, what would your advice be to the Prime Minister at present, or to the law officers, or indeed the Lord Chief Justice?
I think I would want the law officers to be very prominent in their advice as to what can be done, so that what's done is in accordance with the law as understood by the government's legal advisors, whose responsibility it is to advise the government on what the law is.
Have they become too political?
Yeah, well, they mustn't be. I mean, they must. That's an important aspect of the law officer's function, that they can understand the politics, but the really important thing is to ensure that the law is observed by the government they're advising.
They need to be of a calibre to do that, don't they?
Yes, and that's important.
Finally, I mean, funding. Do you think the justice system has had adequate funding in the last 10 years?
Well, I think there's a question about that. And I mean, the delays are absolutely extraordinary.
And that is no good for the operation of justice, is it?
Not at all, neither in that or in relation to dealing with the applications for asylum. I mean, dealing with the applications for asylum is a very important thing. I tried to do to extend the amount of work done in that respect, and promised, that if it was done, it would be quicker. And that happened at the time, but of course that's a long time ago now.
How damaging are the delays in the current system?
Well, I think it's very damaging. I mean, the system requires justice to be exercised in accordance with the time that it happens. And people being kept in prison, in custody, waiting for a trial years and years is just quite contrary to justice. I would love to see the time when the judges' arrangements were according to what the executive have agreed for them. In other words, this delay, this terrible delay, is a sad situation so far as I'm concerned. And I really do believe that there has to be some action on the part of the executive to help the judges in overcoming this delay.
Because otherwise they can't do the job for which they're appointed.
That's right.
And the public ultimately suffers.
Yeah, very much so. Very much so.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.